Good afternoon and welcome to the 2022 commemoration of Law Day. My name is Aslihan Bulut and I have the privilege and honor of serving as the Law Librarian of Congress. It is my great pleasure to greet you all on behalf of the proud co-hosts of the Law Day program, Law Library of Congress, the largest law library in the world, and American Bar Association, the largest voluntary association of attorneys and legal professionals in the world. Law Day is a national day to celebrate the rule of law and its contributions to the freedoms Americans enjoy. A day aimed to promote and remind people to appreciate their liberties and cultivate respect for the law, which is vital to the democratic way of life. So every year throughout May, the legal community reaches out to communities across the nation to stimulate appreciation and critical thinking about the importance of the rule of law. Our theme this year, Toward a More Perfect Union, the Constitution in Times of Change, which fits into this frame wonderfully. And this event is our small contribution to that tradition. Thank you all for joining us, and I hope you enjoy the event. And as this concludes my section of the welcome, I will now hand you over to Mr. Reginald M. Turner, President of the American Bar Association. But before I do that, just a quick reminder, an invitation actually to visit the Law Library's Legal Research Institute site at law.gov, where you can learn about our upcoming foreign and domestic law webinars and events. We look forward to seeing you soon. Thanks again and happy Law Day.
I'm Reggie Turner, President of the American Bar Association. Welcome to the Law Day 2022 virtual program, Toward a More Perfect Union, the Constitution in Times of Change. Our Law Day theme encourages everyone to consider the promises of the United States Constitution and the role that each of us plays in making those ideals a reality. I hope today's panel discussion provides opportunities for you to engage with this theme, think about it substantively, and have conversations in your community about it. Our national Constitution is a dynamic document. It's a plan for government, but it also delegates power, articulates rights, and offers mechanisms for change. It has never been perfect, but we the people, through legislation, court rulings, and amendments, have worked across generations to attempt to form a more perfect union. We've seen these efforts in action, especially in recent years during this ongoing pandemic. Citizens raise their voices loud as ever to fulfill the promises of the Constitution. The 2022 Law Day theme, Toward a More Perfect Union, the Constitution in Times of Change, reminds us that defining and refining those words might be our oldest national tradition. Each of us has a responsibility to help the United States become a more perfect union. So thank you for your participation this Law Day, which will officially be recognized on Sunday, May 1, 2022. You can find additional opportunities to celebrate Law Day and explore the theme throughout the month of May on the Law Day page at www.lawday.org. Let me thank the Law Librarian of Congress, Aslihan Bulut, for her partnership on today's event. We also thank National Law Day Chair Orlando Lucero, as well as the moderator and panelists for today's program. I hope you enjoy the discussion.
My name is Orlando Lucero, and I am from Albuquerque, New Mexico, and I have the honor of serving as the 2022 ABA Law Day Chair, and of joining Aslihan and ABA President Reggie Turner in welcoming you to today's program. I also have the privilege of serving as your host today. Let me begin by thanking ABA President Reggie Turner for his remarks today and for his leadership of the ABA during these challenging times. He has served as an inspiration to all of us. I also must thank Reggie for giving me this opportunity to serve in this capacity this year, and I hope that his confidence in me has been fulfilled. Hot off the presses, I wanted to thank President Biden who this morning issued a Law Day proclamation, and that proclamation will be available in the chat as well as on the Law Day website. Further, on behalf of the ABA, I wish to extend my thanks to Aslihan and to the Law Library of Congress for their partnership and support during the past year during our 2022 Law Day campaign. Our only regret is that we were not able to hold this program in person at the wonderful and beautiful Law Library of Congress. While the pandemic may have upended some of our plans, I think you will find today's program to be inspiring and challenging. We worked with President Turner and his team on this year's theme to create a statement that embodied the times in which we lived and that was dynamic. The word toward, used at the beginning of the theme, suggests movement, not stasis. It suggests that we have the opportunity and responsibility to continue to move our country forward. We intended that the theme, in a broader sense, shows that the Constitution is a resilient document that will continue to have power and vitality, even as our country changes. Particularly today, when American democracy seems more fragile than ever, we felt that the theme would create opportunities to consider and discuss what the Constitution means today. Today represents the culmination of the 2022 Law Day campaign. For several weeks now, we have been working with our partners and stakeholders to make available a variety of programming resources to allow lawyers, non-lawyers, educators, students, bar associations, law schools, civic organizations, really anyone who cares about the role of law in our democratic society, to take the ideas of this year's theme and create programming in their own communities tailored to their community's unique interests and needs. I am especially pleased for the first time, we were able to provide some of these resources in Spanish. And it is not too late to participate in Law Day activities. While today represents a culmination point, it is not the end of Law Day. Like President Turner, I encourage you to visit our website at www.lawday.org to learn more about how you can continue to engage in these important discussions and make every day Law Day. We are fortunate to have a very distinguished panel of speakers for you today. Each of them has a different take on the theme, and we hope that this will lead to some lively discussion. Our program will begin with a panel discussion moderated by my friend and colleague, Professor Stephen Vermeil, a legal scholar, historian, and professor at American University, Washington College of Law. We have reserved some time towards the end of the program for questions and answers, so please have your questions ready. Please feel free to use the Q&A feature throughout the program to submit your questions, and we will get to as many questions as we can, time permitting. With that, I now turn our program over to our panelists, who will each introduce themselves, and then Steve will start leading the discussion. So it's all yours now, Steve.
Orlando, thank you, and it's an honor and a pleasure to be here. I want to thank you and thank the ABA and the Division for Public Education for its long-standing commitment to Law Day, and the Law Library of Congress for its partnership. And again, just to reiterate what you've already heard, we had the pleasure of having a proclamation from President Biden this morning, and it has been placed in the chat so that you can take a look. As Orlando said, I teach at American University, Washington College of Law. I teach constitutional law and have been a longtime friend of the Division for Public Education. I'm going to ask the panelists to introduce themselves, and then we'll come back and hit the topic. So, Elizabeth.
Thanks so much, Steve. I'm Elizabeth Slattery. I'm a senior legal fellow at Pacific Legal Foundation. I'm also a member of the ABA's Public Education Division Standing Committee and host of a podcast called DIST that is all about celebrating dissenting opinions at the Supreme Court.
Thank you. Wilfred?
Thank you and good afternoon. My name is Wilfred Codrington. I am an assistant professor of law at Brooklyn Law School and a fellow at the Brennan Center for Justice. And I am the recent co-author of a book called The People's Constitution. And I am really looking forward to discussing the ideas with the panel today.
Thank you. Sophia?
Hi, my name is Sophia Lakin. I am the Deputy Director of the ACLU's Voting Rights Project, and I want to quickly say thank you to the ABA and the Library of Congress for including me in this discussion today. I'm excited to hear what we have to say. As the Deputy Director, I assist in the implementation, planning, strategy, and supervision of the ACLU's voting rights litigation nationwide. The Voting Rights Project was established in 1965, the same year the historic Voting Rights Act was enacted, and has litigated more than 400 cases since that time, including more than 11 lawsuits just during this redistricting cycle so far, and over 30 lawsuits last year alone during the 2020 election. I guess that's 2 years ago at this point. We have active cases and redistricting challenges and challenges to restrictive voting laws across the country right now, including in Alabama, Arkansas, Georgia, Indiana, Louisiana, Mississippi, Pennsylvania, South Carolina, and Texas, to name a few. So quite busy these days.
We're fortunate that you could take the time to be here. Oren, by no means least, but last.
Happy to be least too. Hi, I'm Oren Kerr. I'm a law professor at the University of California at Berkeley. I'm delighted to be here. It's such a great event and such a great panel. And I teach criminal law and criminal procedure, and I write a lot about the Fourth Amendment to the Constitution, especially in the context of changing technology. So this is a topic that I love to talk about, and really looking forward to our discussion.
Thank you all and welcome. As I think most people know, the words "a more perfect union" come from the preamble to the Constitution, written in 1787. But our question today is how to relate to the more perfect union concept in changing times. And I think our panelists will all have different takes on that question. And so I'm going to throw it back to them again, starting with Elizabeth. How does this topic resonate with you? And we'll go down one by one, and then hopefully have a lively discussion.
Thank you. Well, I first want to say I want to echo my fellow panelists. Thanks to the ABA and the Law Library of Congress. I'm excited about this conversation this afternoon. So when I reflect on the theme for Law Day this year and think about the Constitution in times of change, what I think about is the fact that our Constitution was designed to make it hard to change. And it's a feature, not a bug. Just like the Constitution makes governing hard, the amendment process is hard. Getting 2/3 of both houses of Congress or 2/3 of the states just to propose amendments, and then 3/4 of the state legislatures or conventions to ratify those amendments. That's a high bar. But I think the reason for that is in order to protect our individual liberty from the whims of the majority. As we know, things change. People's attitudes in 1822 are very different from 1922 or 2022. And if we're going to amend the Constitution, I think it should be to expand individual liberty and human flourishing, and not to enshrine today's policy preferences into the Constitution. I think a great example is our nation's experiment with prohibition, which spectacularly backfired. It's a great argument against adopting constitutional amendments that are in effect policy preferences. So what this leads to is, one way people try to get around this hard process is by asking the courts to recognize new rights or adopt new interpretations of the text to sort of change with the times. And plenty of people would ask, what's wrong with that? Why should we be tied to what the founding generation adopted in the Constitution? And my response to that is, well, I don't think judges should decide the biggest debates of the day. I think officials who are accountable to the people through regular elections should be responsible for making the law. They're responsive to their constituents. Just for example, think of two senators who regularly frustrate their parties, Senator Manchin on the left, Senator Romney, Senator Collins on the right. They're responsive to what their constituents want, and I think that's how it should be. Now, I think the best way to ensure that judges don't impose their policy preferences under the guise of constitutional law is to employ originalism. This is a method of constitutional interpretation that just means a judge endeavors to interpret the Constitution according to its original public meaning. It's not always easy and it's not perfect. It doesn't necessarily provide definitive answers, but I think it's the best method that we've come up with. And a majority of the current justices, including ones from across the ideological perspective, are at least part-time originalists. And as we heard in the recent confirmation hearings for incoming Justice Jackson, she also ascribes to the principles of originalism. So that is where I'll stop for now, but I'm excited for this conversation.
Thank you, Elizabeth. Wilfred.
Hi, and I could just say that Elizabeth took some of the words right out of my mouth. And so the theme towards a more perfect union resonates with me because the subtitle of my recent book is 200 Years, 27 Amendments, and the Promise of a More Perfect Union. And so I've been thinking about this concept of a more perfect union for quite some time now. And I think what the framers really did there was they were saying we are pushing towards a more perfect union. We didn't get it perfect, and we could not ever proclaim to have gotten it perfect. And it is up to the American people to make sure that we keep moving towards that more perfect. And so the topic of my book and why Elizabeth and I probably have such overlapping remarks is about the history of constitutional amendments and constitutional change, and specifically through Article 5. And, Article 5 was a wise innovation in history, in political history. Before we had the Constitution, we had the Articles of Confederation, which made changing the Constitution almost impossible. It required complete unanimity from the states. And then, so we got Article 5, which lowered that threshold, which required supermajorities in Congress and the states to get an amendment. That worked early on. The question is whether it's working today, and if so, if not, what we do about it. And I tend to think that, back then it was fine. But if we look at how things have proceeded in history, including the addition of a number of states and a diversifying nation, things have really changed. And that just takes me back to the idea that the framers did not get it perfect from the beginning. And so now we are grappling with that. How do we deal with that? Well, I, like Elizabeth, think that Article 5 should be used. Is it achievable? Well, a lot of scholars think that it's not. I think that we should be trying. We should have a constitutional amendment political agenda. But in the instance where it's not, we also need to use the other levers of government to effectuate that change. Now, I'm not a big fan of judicial supremacy, but I do think that judges are an important part of this. I also think our political branches are a part of this as well, and so are the people as well. We need to have a motivated and mobilized people pushing for change. We all need to be working together to ensure that we get this change. And I am excited to talk with everyone here about what they think are the possibilities for effectuating changes that we all agree and see as necessary today.
Thank you. Sophia.
Thank you. And thank you for those thoughts, Elizabeth and Wilfred. I agree with Wilfred that the framers did not get it perfect at the very beginning. As somebody who lives and breathes voting rights litigation day in and day out, there are many points that come to mind, but two in particular that I'd like to sort of raise up. The first is that, in times of change and in thinking about moving towards a more perfect union in my line of work, I return to the promise of the Reconstruction Amendments, the 13th, the 14th, the 15th Amendments, and the promise to ensure that the guarantees and the points of those amendments, the end of the denial of the right to vote on the basis of race, of equal protection under the laws, that those guarantees continue to remain strong, even as we continue to see changing politics and demographics across the country. I return to that promise. When it comes to civil rights and voting rights work, the story has never been one of linear progress, never been one of just expansion or just retrenchment. Every period of expansion, of change in one direction, has been met with a countervailing force. And so a period of expansion has returned to has been met with a period of retrenchment. And those guarantees in these particular constitutional amendments, there are others that we could talk about. These are ones that I work with quite a bit. Those guarantees serve two functions. In particular, they serve as a backstop during these periods of retrenchment, when there's change in a backwards direction in the way that I see access to voting rights. And they can serve as a tool to increase access, to increase political participation when we are in periods of expansion. I believe strongly that no matter what the period of change is, we're going to continue to see the cycle, periods of expansion met with periods of retrenchment in political participation, and that is on the horizon every day. I do worry right now, and we talked a little bit about the court's role in all of this. I do worry about continuing trends that we're seeing right now towards limiting and restricting the understanding of the scope of the guarantees of these amendments, as well as the statutes that are aimed at enforcing those guarantees. I worry because when you have these more limited views, these cramped views about the scope of these guarantees, you can really constrain efforts to expand access and rights for a generation and require really extraordinary mobilization, strife, violence, just general willpower to and commitment to shift that conversation. One other point that I thought was worth making, and perhaps other panelists have some thoughts about this as well, slightly maybe parallel to what we've been talking about, is at least in my line of work right now, what we're seeing is an increased focus on state constitutions and the different guarantees and scope of guarantees in those state constitutions versus the federal constitution. We live in a federal system with states as laboratories of democracy, and that is a phenomenon that, at least in my line of work, is on particular display right now, and I think is an interesting part of the conversation about what does it mean to move towards a more perfect union when we have these different constitutional documents to take a look at.
Thank you, Sophia. Oren, before I turn to you, just two reminders to our audience. One is, please put your questions in the Q&A at the bottom of the Zoom screen, and we will try to get to many of them later in the session. And also, the text of the proclamation for Law Day by President Biden is posted in the chat, and you're welcome to take a look at that. And Oren, you're up. Thank you.
All right. So great to be here. So I want to actually just start with kind of focusing on how it's a little weird that we're so focused on the Constitution when we talk about Law Day. And the premise of the panel being sort of the Constitution in times of change, and we all love the Constitution is so great. It's a little bit odd that we think so much about the Constitution when we think of law and that we think of society, and that there's almost sort of a way in which discussions of the Constitution becomes like, it's almost like it's like a secular Bible almost in terms of how people speak of it. Like, oh, the glorious Constitution, it is so amazing, and it propels us. It is here, and it's such a focus. And I think it would be healthier if we didn't talk about the Constitution as much, and if we were more focused on just like, what are what are laws we want to have? What are rules we want to have? And we have elected branches to try to bring those about. And we have sort of functioning ways that we can try to make our policy preferences as a collective polity come into being. There are a lot of historical reasons why we're so focused on the constitutions and and a bunch of those have been raised. And part of it is that the kinds of things we care about today were not the kind of things that the founders of the Constitution were terribly concerned about. Some of the aspects of the Constitution are brilliant and timeless and just extraordinary accomplishments in how to structure government, and it's really magnificent. And then there are other parts where in 1787 they were thinking about like, well, what do we do with new states and adding new states to the Union? And how do we amend the Constitution? What will the world be like? And how will all of these rules about kind of how this grows play out? And to imagine, this many years later, to have the same basic constitutional framework, it's parts of the Constitution are timeless, but it's so hard to amend the Constitution that we're kind of stuck with a bunch of features that we kind of have to make do with these kind of antiquated questions of how elections are done and who has exactly which power and how are amendments made. What is the role of courts? What should judges do? What should legislatures do? How do we distinguish among these various powers? And we're kind of in a world where we have to make up a lot of the structures in non-textual ways and through a bunch of assumptions about what the rules should be. And don't get me wrong, this is great for law professors. Like, this is awesome, because for law professors, we can be like, oh, I've got a theory about how to interpret the Constitution. And then like that becomes like not just like, some academic's view of like, oh, there's some document, you should look at it this way. It's like, no, like this is the way to interpret the law for all, binding in the entire country. And so I think, a lot of the debates over the role of the Constitution and constitutional theory exist because the document is so hard to change, and we're kind of stuck with a bunch of features that may not make a ton of sense today. And in order to work with that, what happens, anyone who's studied any law, sort of what happens when the rules don't give you kind of what you want, or they don't seem to fit the problem that you want them to fit. You start thinking like, how can I interpret this in different ways? Like, they start playing, and then there are all these like interpretive tools that lawyers learn about how to take language that's doing one thing and say, well, you can start doing a little bit of a different thing, and we can get into a world where we rely on the Supreme Court to solve a bunch of problems. And I think I should say both sides are guilty of this. Each side sort of has when we talk about sort of constitutional theory, it's natural, I think, for people to be attracted to the constitutional theories that roughly will tend to deliver the set of results that they want. So there's a lot of choices that go into how you think about the Constitution, and for the most part, people tend to find appealing the interpretation, so schools of interpretation that are going to kind of be roughly coincide with the results that they want. But both sides, I think, have their kind of, the court should get out of the way in this area, and the court should really get involved in this area. And what do you know? They kind of roughly match the sort of, roughly speaking, political agendas of the two political parties, or at least rough ideologies. And so I think we there's so much that we are doing that we should be doing more directly through voting, and like we have elected officials that should be doing like, it's sort of a novel concept as to just if there's a rule that society should have, like, let's generate support for the rule. And like sort of the I'm only a bill on Capitol Hill old video, like it should work that way. And instead we have a lot of thinking about law and theory and constitutional interpretation that kind of, we end up in this world in part because our institutions and the constitutional structure kind of put a lot of power in that setting. And I think part of it is that the U.S. Supreme Court is an amazing way to federalize power. One of the characteristics that several of my co-panelists have talked about that makes the United States really interesting and different is the originating power, the fundamental power is in the states, and then the theory is that the states give up their power part of their power to be part of the federal United States. And so the theory is that the states do most of the stuff, and then the federal government just does the federal stuff. When I explain this, when you teach law students about this stuff, they're like, really? Wait a minute, it kind of seems different. Because the federal government has extraordinary powers, and it has so much power, and yet the structure of where the power comes from, the idea that California with 40 million people has the same power in the Senate as Delaware with less than 1 million. And don't get me wrong, I live in one state and grew up in the other, so I'm allowed to pick those two states as examples. That's really weird. There are great historical reasons for that, but now that is really weird. So to have so much of the power be in institutions that were not designed maybe to have all that power, and then you have the Supreme Court, which is even more divorced from these questions, and it's even less sort of democratic in terms of, the president is not elected in a pure democratic election, and the Senate, which confirms that's not pure democratic either, and yet we have the Supreme Court that then can federalize anything, because when the Supreme Court says there's a right to X, that means everyone has to follow X, and so it's a quirky system where we're relying on all of this law and judges and courts to do things which, if you had to kind of step back and go, how would you design a system from scratch? There are parts of it, as I said, the founders were brilliant in how they separated powers and how they, created this interlocking system of different roles of government. It's really amazing. But they couldn't have imagined the world, I think, that we're in, and they didn't design it for that. And a lot of the weird conversations we have are weird because of that long period of time that's passed and our struggles to kind of update the system that we have. So what we do have is a world in which when we talk about the Constitution in times of change, that means the courts. And I think every time is a time of change in that sense. So I don't think we're now in more of a time of change than any other time. And I always think about these questions through the lens of, I do Fourth Amendment law, which is searches and seizures, like police investigations. And that area of law is constantly dealing with new technologies. So the people are using new technologies, so there's evidence in new technologies, or the police get new technologies to gather evidence, or people engaged in wrongdoing that the government is looking at, they're using technologies. And so how to deal with new technologies is just this constant theme. And my favorite example of this is cases which today look like they're just standard sort of cases that don't involve change. When they were created, it sure involved change. So 100 years ago, the big question was, how do you interpret the rules for searching and seizing cars? Because, imagine you have horse and buggies from the founding until around 1900, suddenly people are driving cars. And by 1920, you had a couple really important developments. First, a lot of people had cars, Model Ts are everywhere. And then second, you had prohibition, which was mentioned earlier, which not only was federal, but also happening at the state level in many states. And so you had suddenly everybody, that basically folks were going around with their whiskey in their cars. And the government was like, well, how do we stop people from carrying all their whiskey? We have these new laws, and how do we enforce them? And in the early 1920s, how do you apply the Constitution to stopping and searching a car was this huge technology question of the day. And so the courts dealt with that. In 100 years ago, it was how do we deal with times of change? The car. Now we may deal with times of change, computers, the internet. But every era is going to have the same question of sort of how do you deal with the latest technology? And in that sense, we're in a time of constant because change is the constant.
Thank you. I imagine that among the four of you, there's been a lot of thoughts there that others would like to respond to. So I have a bunch of questions, but I think I'll give you all the chance to have at it first. Elizabeth, you seem to feel like you would like to start off.
Yes, sure. So a couple of things. The first thing that I want to mention, I want to commend to all of our audience today is a few years ago, the National Constitution Center undertook a project with 3 teams, a libertarian team, a progressive team, and a conservative team, to write updated constitutions. And they're really fascinating. I think each team had 3 or 4 scholars from different areas, and I would recommend you check those out and see the ways in which these different teams, what conclusions they came to about what things they think still work today, and if they had to start from scratch, how they would change the Constitution. Interestingly enough, the Libertarian team had the least amount of change, I think, because in their introduction, they said something along the lines of, well, the Constitution is fundamentally a libertarian document. So I would commend that. It's you can find it all on the National Constitution Center's website. But Sophia mentioned state constitutions and the laboratories of democracy. And I think it is important that we remember that we do have state governments and state constitutions, and we should look to those and not always, to steal a phrase from Oren, not always try to federalize everything. And so I'm heartened to hear Sophia bring up state constitutions, because I think there is a lot to explore there, because our federal constitution was not intended to cover everything, and left a lot up to the people and the states.
Other people want to weigh in, Wilfred?
I also wanted to pick up on a couple of things there. And as Elizabeth noted, Sophia's indication of state constitutions, I think they are, and it is very interesting. This sort of is in alignment with what Oren was saying. How, when we look at state constitutions, the way that they are used depending on the period of time. So right now, we see progressives looking at state constitutions to try to articulate their vision for policy and for how we should be governed. And this was happening sort of in the Trump era, when we were sort of in a position where we didn't know what was going on with the national government. And so we look to the states to actually be the defenders of democracy. And we see that happening with conservatives. They've done that very much the same way when liberals were sort of in control of the government. So we do see this sort of use of the tools of government sort of vacillating and changing depending on who's in control and what we want to see operationalized or put into effect. One thing I also want to note about state constitutions is, and this, I'm sure, Sophia, this is up your alley, is this idea of that's now being put out there, that state legislators are above their state constitutions. And that is, of course, the independent state legislative theory. And so there are many instances in which the Constitution gives control over elections to state legislators. But now, so for the Electoral College, for example, or just generally regulating elections. And now what we see is this sort of off-the-wall idea that when the framers wrote state legislators, they just meant only state legislators, not state legislators as bound by the constitutions of their states or as answerable to the courts of their states, as we know we have in our sort of structure of government. And so state constitutions themselves are not insulated from being manipulated in ways to try to achieve these anti-democratic and illegitimate ends. And so we see that there. I also want to just note, Oren raised the idea of being constantly in flux, and that's true. I think, though, at least the way I think about it, and it sort of aligns with the area that I focus on, which is constitutional reform and amendments. When things get way out of flux, out of sort of whack, when we get lots of technological updates that we cannot deal with, that's when, in the past at least, we've taken to amending the Constitution. And that's when we've taken to trying to grapple with those within the framework, our broader framework of government. And yeah, we're all talking about the Constitution. I'd love to not talk about it or I love talking about it. I'm a constitutional theorist. I teach constitutional law. So that kind of answers Oren's question. Why do we get fixated? People like me. He's talking about people like me. Yeah, but it is both a fantastic and wonderful document and also totally out of date and in need of upgrades. And I think it's a need of upgrades textually, which is very, very difficult. And so I'd love to get back to that or have people jump on that and talk about how we get to that change, but also updated, knowing that it was written often in these broad and general terms because it is so difficult to update that we need to have it be flexible, to take into account changes that are occurring in our politics and in society that cannot be taken into account in the text of the Constitution itself. Let me just remind the audience how short our Constitution it is. It is under 10,000 words. Like, I write papers that are longer than our Constitution all the time. And briefs, all of our panelists are writing briefs that are longer than the Constitution all the time, right? So obviously it can't take into account everything. And even more, were we to be faced with the situation that we are now, perhaps we'd write a longer and more detailed Constitution to take into account these eventualities in the way that most countries have gone in the post-World War II era. So there is, again, profound genius in our Constitution, but it is also out of date in many regards, and that's what we're dealing with today.
Yeah, let me give you a chance to weigh in.
So I'm glad that so many people have picked up on the state constitution point that I raised. Wilfred took some of what I was going to point out with respect to the independent state legislator theory. But I think what's interesting about that point goes back to this concept of whether or not we're trying to federalize everything. I think it is very true that different tools, different strategies are employed by different groups of people advancing different types of things at different stages, whatever fits the moment. I think that's sort of the point. And what we're seeing right now is an attempt to use, I think, the federal constitution to sort of tamp down on the ability of states to do what they will with their own statewide constitutions and the powers that they have within their state. So it is interesting to see sort of the flip in the ways that people talk about states' rights versus federal rights and so forth, given the moment. That is very true. And I'm definitely seeing it at play right now. I did want to sort of raise up one point that Oren had stated, which is with respect to using other branches of government, maybe electing, doing what we can, doing the work that we can to elect the people that we want to do the things that we would like to see outside the concepts of the Constitution, outside the context of the courts. I don't disagree with that, but in the work that I do, I see a lot of constraints with that sort of general idea. I'm in the midst of a lot of work surrounding redistricting and the really terrible gerrymandering that we're seeing on both sides of the political spectrum, and this happens time and time again. And the fact of the matter is, we have a Congress that is gridlocked most of the time. And so when you have lack of movement in any direction, and you have politicians able to continue to stay in power, essentially, because they have the controls over how they're elected. And so without some sort of outside force to change that system, you can get stuck in a little bit of dysfunction. And unfortunately, at least from my vantage point, and I imagine there are many people sort of watching what happens in Congress, watching what is not happening in Congress for quite some time now. I think the reality of the dysfunction is quite clear. And what we're seeing with the sort of redistricting cycle from my vantage point is that is going to be entrenched for another generation, absent some other movement to change. So in some ways, we actually need some more change right now. From the perspective that I am coming, the trend that I am seeing is just one that unfortunately suggests that there is true flaws in the constitutional structure that we need to figure out a way to get out of as a country to continue to thrive.
So let me throw this back at all of you from what I've heard. This is a great discussion, but what I'm hearing, and forgive me, this is going to be severely truncated summary, but what I'm hearing is the Constitution in times of change is what Sophia just said. It's stuck. We should be using the amendment process because that's what it's there for, but we can't because we can't agree on anything. We shouldn't resort to the courts because they're not supposed to be the answer in the absence of the democratic process working. The democratic process is hopelessly gridlocked in Congress. The state legislatures are all over the place. The state constitutions are all over the place. So what do we do?
You could hand out tissue so we could cry.
But there's got to be a pessimist in every crowd, right?
No, and
Go ahead.
no, I think that's a pretty accurate description of descriptively where we are. And I think a couple of things. One part is that, you know, when it comes to matters of government, we always kind of just muddle through, right? Like perfect answers are usually not going to be on the table. So the question is sort of how bad is it? But I think also, you know, some of this is I think it's not always going to be the case that we are so deeply divided, kind of 50-50 politically on the major questions of the day, or at least my impression is that there are structural fault lines and problems that can prevent our system working well that come out most when it's just like so close to 50-50 parity. All the incentives go towards, like, you know, if it's like 48-48 and we're just fighting over that little pieces, well, anything you can do to kind of fix the system, to sort of add in a structural bias your way, that could make the difference between winning and losing. And that's where, you know, the gerrymandering, and which I completely agree, Sophia, it's horrible. And I think, you know, if we could solve that problem, it would go a great way towards improving the system. But, you know, in a world like, I think back, you know, sort of you look at national politics, like, you know, 60 years ago, 100 years ago, 150 years ago, usually it was like one side was like clearly winning. And you could be like, oh, you know, in the 1930s, the Democratic Party was winning. And then you look at the Congress or the Senate in the 1930s, it's like, you know, what is it, like 75-25 or something like that, like huge. And so that's a totally different world where you don't have this angling for any possible slight advantage. And so one answer might be that in time, one party might actually get enough of an advantage such that all of these structural flaws matter a lot less, and maybe can be solved then. I don't know.
Other thoughts?
We have to learn to compromise. President Ronald Reagan used to say, if I can compromise and get 70 or 80% of what I want, I'll take that as a win and come back for the other 20 to 30% another time. So I think both sides of our politics need to learn to work together a little better and compromise.
I'll chime in here. I mean, there's a couple of things that I'd love to chat about. One is the role of the courts. So I'm not a big fan of the courts being involved in everything, but a point that Sophia highlights is that, you know, and this goes to constitutional theory. Sorry, Oren. People on this call will be familiar with a scholar called John Hart Ely, and he raised up this idea, this representation reinforcement, political process, and part of it was that, you know, courts need to be involved to protect the guardrails of democracy. They need to be involved when the normal political process is being obstructive and choked off. And so a clear instance of that is one of the ills that we're all talking about today is gerrymandering. But the court has absented itself from that in the Rico ruling from just four years ago. So we know that what state legislators are doing is they're gerrymandering the heck out of these things. And some state courts are weighing in and striking them down, saying these are too partisan of gerrymanders, so you're diluting the vote of a lot of people and you're not allowing the people to choose their representatives. It's vice versa. But some courts are not doing that because it's captured by this sort of same ideology and the same angling for advantage. And so when federal courts are absented from that, then we are stuck. That's part of the problem. And then another part of what's been raised is talking about some of the structures. And in some regards, I agree with what Oren has said. You know, there have been times in history where there's just been overwhelming control by one faction or another. And that has happened really when we've amended our Constitution, right? During the Reconstruction, in the lead up to the war, and the South was basically left the country, you know, you had overwhelming radical Republican control and they could pass constitutional amendments. During the progressive era, you had this realignment where you had functionally three parties, but they sort of thought about certain issues, and you got 4 amendments during that period that they could agree on. During even the 1960s, you had conservative Democrats and liberal Republicans, but they agreed that some of these updates to the Constitution were necessary, particularly to protect democracy and voting rights. And so we saw those, but I'm not certain that we are both at a sort of inflection point where we're seeing some of the same types of things come to a head. But I think those structural barriers in the Constitution are really challenging. Oren raised the Delaware and California thing, right? So if we need to get 2/3 of the Senate on board to pass a resolution to amend the Constitution, that seems near impossible. And so I mean, it's very difficult. That is a very difficult structural barrier. It's a very difficult structural barrier when you can elect the president by a mechanism, despite the president losing, 3 million votes to his nearest competitor. That's a problem. And then we went back to gerrymandering, that's problematic. And lifetime tenure for the courts, right? We have these, it really politicizes the process of confirming judges. It sets these litmus tests that are really impossible to achieve, and it disincentivize well-meaning and well-intentioned people from going into public service in a way where you could be berated and dragged in through the mud, as we saw with Ketanji Jackson. And so, I think we have these structural barriers that we really need to think about, but to get to the point where we can reform those structural barriers, we have to surmount those structural barriers. So this seems to be a chicken and egg problem right now. But I'm again, other than just having a tissue, I'd love to have some more ways to kind of think about how we approach it.
So since my tissue box is almost empty, let the pessimist try to redeem himself and ask, what did the Constitution get right?
I'm happy to start that out. So
sure.
Oren mentioned at first, he mentioned the separation of powers. So I think in general and in theory, that was fantastic, right? That was one of those innovations where you have no particular agency or official or branch have too much power. And of course, by keeping excessive power from any organ of government, we're preventing any organ of government or person from becoming autocratic or oligarchic, and therefore disabling them from tyrannizing the people. So that also encourages cooperation and competition between the government, and collaboration and conflict, to make sure that when we get to these policies, they're really great. And I also just want to raise up the idea, again, in general, Article 5, that we didn't have this real mechanism for reforming the Constitution, and now we do. Now, I think, one, that shows that the framers themselves saw themselves as fallible, right? These men, and I will emphasize men who participated as delegates in the Philadelphia Convention, half of them owned slaves. So we know that they were not infallible, right? And we've had to use Article 5 to update the document on 27 occasions and to extirpate a lot of flaws, including slavery. But Article 5, I think time has shown that they got the formula wrong. right? By adding a number of states to that, it really problematized and raised the actual threshold, the difficulty of amending the Constitution, and not to mention what we have to do in the states. So I think in general, and in theory, the separation of powers was great, but it also has proven to have some weaknesses. And I think in general and in theory, Article 5, generally incorporating an amending provision in the Constitution was great, but it also has its theories problems.
Other thoughts? Oren, go ahead.
Happy to go next. So, I mean, if I think of the Constitution, I mean, we've talked about its flaws, but if we're now turning to the good part, you know, it's sort of extraordinary that you have a document created in the 1780s that is still in effect and went from a very small country that wasn't doing much, that nobody was thinking very much about, to the most powerful country in the world, which is, you know, more than 300 million people and occupies an enormous landmass. And it's the same document that is governing that. I mean, that whole idea is sort of amazing. I mean, most countries, if you ask sort of how old is your Constitution, you know, they might have a Constitution that's like 40 years old or 20 years old, or, you know, we got one recently. So the idea that we're still working from the same basic framework, you know, obviously it's been amended, but that's incredible. It's really incredible. And so I think the structure of it, the separation of powers, the Bill of Rights is an amazing achievement to put into a national constitution. Here are the rights which everyone is entitled to. You know, and it's hard to talk about that without the flaws like slavery, which, you know, sort of are so, you know, obviously when you say that, you sort of think that, but the fact that, you know, obviously that was, you know, able to be amended and to apply to all, I mean, that's extraordinary as an accomplishment. And so, you know, I think we're right to look at the Constitution and say, wow, that's amazing. It's just that it turns out there are also some problems which matter a lot to what we're doing today.
Other thoughts?
I'll go next. So I think the Bill of Rights is great and all. Other countries have Bill of Rights. You know, look at the North Korean Constitution, the Chinese Constitution. They guarantee things like the right to relaxation and freedom from insults, which sounds great, but without the structural protection that we have in our Constitution, those rights are meaningless. And so I think, you know, unfortunately, part of the structure is not living up to its expectation, in that the branches don't always check each other in the ways that we would hope that they do. You know, we see with the court, for example, in the area of administrative law, with all of these deference doctrines where they defer to the executive branch on what the law means. And that's not the way it's supposed to work. They should be pushing back on what the executive branch says. And, you know, Congress, instead of jealously guarding its lawmaking authority, it's giving it away. It's setting up independent agencies and giving power to executive branch agencies freely, because then they, you know, members of Congress get credit for doing something, you know, making the air clean, but they don't actually have to do the hard work of compromise and figuring out how to make these policies work. So I think our structure, the structural protections, is the greatest protection for our individual liberty, but unfortunately our government today doesn't always live up to those ideals.
Sophia, I missed you in the last round.
No worries. I agree with so much that has already been said, that both the sort of longstanding general principles that were part of the original framework, separation of powers, just the rights that have been given, as well as the process to be able to recognize that we need a process to change, update, and we have done so. We live in a moment right now, I think, like I've said, highlighted before, of what feels as if there is very strong dysfunction in what we have going on. The Constitution, this country has been in these moments before, and has, as Orna has pointed out, we've survived them and managed to make our way through using the same structures that we've had. Yes, they potentially have changed through the amendment process, and we may need to think about that. There may need to be other structural changes that happen over time, but I do agree that that is a testament to the ability of this document, of the sort of scope of it, the flexibility that's inherent in it, as well as some of the structural pieces that maintain the general house. And while I'm living in this moment and feeling nervous about the ability to make our way through this, when I look back at historical times and think about these moments in time in history where we've felt, I think, that there was probably very extreme dysfunction, and yet here we are today. So that's what I take away and continue to think about. The one other plug that I would have in terms of, not being, what can we do today in the world of this, what feels like dysfunction, especially at the federal level and especially at the statewide level, national politics and so forth. And I always encourage that you start local. You do start local. And many of what I do think that we do talk about these constitutional principles. We think they're important. They're extraordinarily important. We often end up talking about national issues, national concerns, but and the day-to-day level, what your day-to-day life is like in your community, all of those policies, that the alternate side street cleaning, for example, housing policies, education policies, policing policies, these are happening at your local level. And there is a lot of room for for people to be responsive to what your community would like to see. And that doesn't get as much attention in anyone's minds, in my view. And there's so much work that can be done there. And I do think that if you start at that local level, it can bubble up ultimately over time.
Let me remind the audience, we will turn to questions in about maybe 8 or 9 minutes. And the questions need to be in the Q&A feature on the bottom of your screen. We're not going to take raised hands. We're going to answer from the Q&A. Sophia, the last point you were making, let me ask that in a slightly different way. Isn't one of the reasons that we are concerned about the Constitution in times of change and concerned about where we are in our society today, the growing distrust of authority, of agencies, of government, of all kinds of entities across the board, distrust of the media, distrust of the police, distrust of elections, distrust of Congress. I mean, how do we sort of move forward and keep the government that we have if this distrust is growing exponentially?
How we weren't going down the pessimistic route still, but I will stand by what I have said in terms of starting local. And I do think that if the people on your city council, your city board, your neighbors, people that issues that you care about, in communities the schools that your children go to, it's a great place for the people, and there's responsibility on the people that are in these offices to go out and do the work to get to know the people that they represent and build that trust. But it is a great place to start in terms of rebuilding people's trust in the civil servants, the public servants that work in our government. And I strongly believe, as somebody, and I'm primarily working in the courts, but I'm interacting with all sorts of policymakers and in different arms of government, that the vast majority of these people do this work because they care about the well-being of this country, about the rule of law, about what policies make sense for their communities, about moving this country in the right direction. They may not agree, but the impetus of why they're in that office in the first instance, what they're trying to accomplish, knowing that they could be wrong, is what is motivating people. And I think in order to rebuild a lot of that trust, I do continue to believe a lot of it is starting at that local level, seeing people respond to the needs of your community, understanding that it does work, and then going from there.
Anyone else?
Yeah, I'll jump in. So with respect to lack of faith in the Supreme Court, I think it's important for people to actually read the Supreme Court's opinions and look at the cases, where people in the media have said this justice will rule in such a way, and compare it with what really happened, and consider their reasoning for reaching that particular result. If you look at recent confirmation hearings, soon to be Justice Jackson, she was called a lot of things based on her rulings in dealing with sex offender cases. But if you actually go and read the opinions, it's hard to see that these attacks really had much merit. If you go to Amy Barrett's confirmation, she was called a targeted missile aimed at the Affordable Care Act. But then she was confirmed and she voted to uphold that law in a case with 6 other justices. Neil Gorsuch was called a rubber stamp for the Trump administration to strip away anti-discrimination protection for LGBT individuals. But then he wrote the majority opinion in a Title VII sex discrimination case, including discrimination on the basis of sexual orientation and transgender status. Brett Kavanaugh was also, people said in his confirmation, well, a lot of things, I won't get into all of that, but said that he would vote to expand gun rights. But then last term, he voted with the majority to turn away a major gun challenge. If you look at how the other justices, not even the newest justices, vote, they often rule in ways that defy their labels. Justices Breyer and Kagan have sided with the so-called conservatives in a number of cases implicating the religion clauses, the Colorado cake bakers case, a case upholding a 40-foot cross on public land, and others. And so I think it's important for people to do their homework and not just take the media reports at face value, but read what the Supreme Court actually says, because I think it's extraordinary that they, we were talking, some of us before this started, how Supreme Court opinions continue to get longer and longer, and maybe they need more work because they have all these law clerks and they keep writing all of these really long opinions. But it's extraordinary that they explain in detail their thinking, and even the ones who don't agree with the opinion will shine a light on the defects that they see in the majority. And so I think people should do a little homework and go and read what the Supreme Court has to say. And I think I hope that would improve their faith, instill a little more faith in that institution.
Oren or Wilfred, let me give you each 1 minute, and then we're going to turn to Q&A.
Yeah, so quickly, I have a little response to both of Elizabeth and Sophia. Elizabeth has a great point, which is that we should do our work and read the opinions that the court, but that's when the court gives us opinions. The court is now ruling in ways that they don't even provide rationale. And the framers said, look, the court does not have the power of the purse. They do not have the sword. All they have is judgment. And now they are actually changing the law, changing the merits of the law on a non-merits docket. It's been called the Shadow Docket, and they're doing it increasingly in voting rights cases. They're doing it on cases involving religious liberty. They're doing it in cases involving abortion. And so it is really difficult to actually read what they're doing when they give us zero opinion and just rule. That is fiat. And to Sophia's point, she said, look, most of the government servants are trying to do a really good job. They're not trying to be caught up in all of this. And, to the extent that they are getting caught up, a lot of this has to do with the fact of our political party system, right? We have a very nationalized politics. That was not always the case, but it kind of became it shortly after the Constitution was ratified, before the ink was dry. The framers did not anticipate, and they actually said that they detested the idea of these factions of political parties, and yet that's kind of what dominates our system now. So even on a local level where we might, if you frame a question one way, we might agree with it or disagree with it, If it's put in the terms of the politics that are nationalized, then we think about it completely differently. And so maybe we need to be thinking about how we might better regulate parties, governing rules, fundraising, opening the process so more voices and other voices could actually be taken into account. And we don't have this permanent entrenchment of a two-party system, so we cannot have real deliberative discussion and solutions.
Oren, 1 minute to wrap up, and then we're going to go to Q&A.
Yeah, I share Wilfred's concerns about the so-called shadow docket and all of these apparent decisions in the context of emergency petitions and the like. It's a terrible way to do business, and it's actually, I think it's a recurring theme when you get a Supreme Court that has a kind of a center vote. The power on the court, it takes 5 to have a majority and to do something on the Supreme Court. When you have a fifth, that center vote is pretty far different from the precedents on which the court is otherwise relying. What ways does that majority tend to express itself? And we had a period of the Warren Court where one way the majority expressed itself was through issuing 160 rulings a year, sort of massive numbers of rulings that got pretty sloppy, and the justices were not terribly concerned about getting all the legal details right. Our current court, as much technically, is so much better than the court of that era. And it takes many fewer cases, but at the same time, now we have sort of that same push to change a lot really quickly, and it's coming through this very odd context of emergency petitions and the shadow docket. And so it's I think a recurring problem of how do you do business with a court that wants to make changes, and what's the procedure for doing that?
All right, thank you. Thank you all panelists for a wonderful discussion. Let me open up the Q&A. I see a couple of questions that sort of relate to how the Constitution is going to deal with changing technology. One asks about biocybernetics, artificial intelligence, brain implants suggested by Elon Musk. And then there's another question that notes that the constitutions of Poland, Ukraine, and other countries have articles addressing the right to development of your own personalities. How do we feel that plays in here in light of neurotechnology, and how do we deal with developmental rights? So let's maybe start with those two kind of combined. Oren, that might be up your alley.
Sure. So a couple of points. So first, when we talk about constitutional rights, with the exception of the 13th Amendment against slavery, we're talking about rights against governments. And so what can governments do is the issue, not sort of what do you have a right to do kind of in a more abstract sense. So the questions of new technology are typically going to arise when the issue is, what powers does the government have to investigate somebody? What powers does somebody have? Does the government have to limit someone's ability to use a technology? And so usually the sort of default is that people have, state law is going to determine whether somebody has an ordinary right to do something, and then the Constitution will kick in when it's something that touches in on one of the kind of specific concerns of various constitutional amendments. Search and seizure is going to be an issue when it's, for example, the government gathering private information about somebody, or the privilege against self-incrimination when the government is making somebody speak. And so some of these technologies touch in on that. So there's questions like, with brain implants, to what extent could the government could use those to figure out someone's thoughts, and that might be prohibited by the Fifth Amendment privilege against self-incrimination. There's been sort of academic speculation on this, but it's hard to say. And part of the problem is that the way our system has tended to work is that we get hypothetical scenarios where we wonder, I wonder how the law might apply to that. And then we get cases where the courts grapple with how the law would actually apply to that. And then the Supreme Court, 20 or 30 years later, steps in. Usually the Supreme Court steps in to resolve what we lawyers call circuit splits. It's sort of like a lower court has disagreed with another lower court, and you just don't know what the law is. And then the Supreme Court takes the case to decide what the law is. That's a long way down the road. And so it's often the case that by the time we know how the Constitution applies to a technology, the technology is ancient, or at least is no longer cutting edge. So a lot of times it just takes years to figure out what the answers to those questions are.
Anyone else on that question? All right, Elizabeth, this one looks like it might be for you. What's the argument against SCOTUS deference to executive authority? Wouldn't it be dangerous to have a non-elected branch of government impede the mandate of democratically elected leaders?
So I should clarify what I was talking about is when an agency or an executive department is interpreting a statute that gives it authority. And if that's challenged in court, should the courts put a thumb on the scale for the government's interpretation or treat the private party and the government equally and hear their arguments and then decide who has the best argument and rule that way? Under a number of these deference doctrines, most famous is called Chevron deference. Courts are bound to side with the government. And I think that's pretty unfair to give the most powerful litigant in the country, the federal government, that benefit that no one else has.
Thank you. Anybody else? All right, these are two different questions, but I'm going to try to combine them into one. One question is, what do we do to shore up the separation of powers given the last administration? And the other question is, how do we deal with the failure of elected officials to comply with their oaths of office to uphold the Constitution? Let anybody tackle those.
I'll start with that, just to know that that is a huge question, not to say that the other ones were not. But I think, so I sort of noted the separation of powers was one of these great innovations, but what's going on operationally, you know, the devil's in the details, right? And I think over time, it has shown some vulnerabilities. And one of those is, there's a scholar, Rick Pildis, who wrote a paper called The Separation of Parties, Not Powers. And part of this has to do with when you have single government control or government control over enough of the organs of party control over enough of the organs of the government, well, you're not going to get much in terms of dissent and pushback. And so Elizabeth has raised rightly, like, you don't get dissent from the parties. Congress is not jealously guarding its powers. We've seen the expansion of executive power, for example, in war, right? Since we have not declared a war since World War II, and yet we all know that we've been engaged in military conflicts. So what is going on there? That's something that is universal. Democrats and Republicans alike, Congresses have just ceded their power in that regard. This happens in other ways as well. So I think, you know, to deal with the separation of powers and to have it actually intact, we need to be thinking about the parties and how those two things coincide. And in terms of officers not really keeping faith with their oaths, I mean, that has become so deeply problematic. And I think, you know, this is one of those points where we're seeing the Constitution is not up to snuff in dealing with this, right? So now we're looking at innovative ways to invoke a sort of obscure section of the 14th Amendment that related to insurrectionists from the Civil War era to try to keep people off the ballot, try to keep Donald Trump from running for office again. You know, that I mean, if possible, yes, but it doesn't seem like that is working. We've seen that the impeachment power just does not work. If you know, someone inciting insurrection on the government and someone inviting foreign powers to get involved in our elections is not an impeachable offense, or it's not capable of showing being impeached, then we know we don't really have a mechanism for ousting an official at the highest level of power in our government. So I think these are those things where we're actually showing the cracks in the Constitution, where it's not competent to govern in these areas, you know, 230 years hence.
Anyone else?
I will just add very briefly to what Wilfred has said, to point out again this point that where you have elected officials that aren't doing their job, the number one course would be to do what you can to ensure this person is not reelected. And so pitch for getting out and voting and getting your neighbors to go do what they need to do and, you know, participate and get out the vote election efforts where you see that happening. That is a mechanism that has broken down in times, but it still remains as the classic way to ensure that people are elected officials are doing what they're supposed to be doing and are not elected if they're not doing what they need to be doing.
I just add one small way in which I think the system could be improved would be if courts, when facing separation of powers disputes, especially involving the executive branch, act very quickly. Because what we found in the Trump administration was that the sort of masters of delay. You could basically say, all right, it'll take 5 years to get litigation all the way up to the Supreme Court. And so what difference do courts make if they never make an enforceable rule? If you don't get to the end of the appellate road, you know, till years later. And a lot of times there were cases where it just didn't matter what the trial judge was saying, because obviously any ruling was going to be appealed. And then the trial judge would take like 2 years or a long time to figure out what their answer was. And so I would just say, you know, if you're a trial judge, you get one of these cases, like, you know, it's all going to be appealed. It's an issue of law. Do it really fast, because what matters is that the separation of powers works in that there is enforceable ultimate judicial rulings. And I think that was another sort of flaw that was discovered. The ability to delay really prevents the enforceability of rules. And I would love to see sort of better responses from the judiciary in terms of dealing with that.
Perhaps authorizing original jurisdiction in the Supreme Court when it comes to a separation of powers issue. That would be quick.
That would be quick.
That would require a constitutional amendment. Oren, this one looks specifically aimed at you. Would the differing interpretation approach just serve as a legislative bypass rather than apply the law of the Constitution as written?
Yeah, so I think the different approaches to interpretation are trying to figure out how to apply the interpretation as written. And the challenge is that there's the nature of interpreting language when you really, where there's a will, you know, a lot of times there's a way, in the sense of if you look at the language long enough and you really, really want to reach a different result, you can come up with your textual interpretation. You can raise levels of generality. You can look at words in different ways. There's sort of lawyerly tools for how we make arguments on behalf of clients. So, and I think it's ultimately unavoidable. And you know, there are more textual ways of reading and less textual ways of reading. It is very hard to be consistent across the board and to say, like, listen, I'm always going to interpret the language a particular way, and if that creates truly crazy results, sorry, that's my method. People tend to, you know, sort of read language in ways that leads to results that they find at least not terrible. And so I think ultimately debates over what theories are used to interpret language, I don't think they do as much work as we sometimes claim they do. It seems to me there's sort of broader conceptual questions like, what is the role of the Supreme Court? Should the Supreme Court play a major role in society, or should the Supreme Court be very modest? I think that actually like plays a bigger role in the ultimate question of what the Supreme Court does than some of the constitutional theories that we focus on often.
This question uses the recent decision about denying citizens of Puerto Rico disability benefits, but asks the broader question: how does the panel feel about recent decisions of the court indicating a conservative supermajority that might affect the interpretation of constitutional rights? Don't suppose anyone has any thoughts on that.
So I'll just take a stab at, I guess, starting with the Puerto Rico part of this. I think what the decision shows, and this is a case that basically says that the federal government can exempt people from Puerto Rico from receiving SSI benefits, even if they've lived in the United States and sort of retired there, which was happening in the case. You know, this again, and I see a lot of these as problems, right? Like, this would not happen if Puerto Rico and Puerto Ricans were able to actually vote and have their vote counted for something in our larger elections. And this is not just something that's unique to Puerto Rico. It's also the District of Columbia, right on the mainland, right? Like there is just no representation in Congress and particularly in the Senate. And so these are problems that will arise, and they are more or less left as wards of Congress at best to resolve these issues where there is just a substantial amount of people, often mostly people of color, who are just not included in We the People in this way. And so I just see this as a small sort of symptom of a larger problem of who is being counted as a part of We the People. And we know this goes back, back to the founding, right? We've had a great amount of expansion of incorporating more and more people, becoming a more diverse nation, but we haven't completed the job. And I think this recent case of the Puerto Rican man who's now, I guess, liable for repaying these Social Security benefits, he just shows is just really something that's really deeply problematic that we really need to be thinking about more seriously, and not through the lens of partisan gamesmanship, who's going to be advantaged, which political party is going to be advantaged, but from a place of American sort of fundamental rights and human dignity.
Anyone else on that question? All right, I think we are, I apologize, there are a couple of questions left, but we are out of time. And so I would like to thank the panelists for what I thought was a great discussion. And I am going to turn it back to Orlando, our host, to sign us out.
Very good. Well, thank you very, very much to everyone. I think we definitely got exactly what we were hoping for from this panelist. And I think probably most of us could have continued listening to your discussions for a long time, because I think they were very, very fascinating. And I think with almost every comment or with any question, we could have gone so many different directions and explored so many different issues within it. And I think it also just shows us how nuanced and all of these issues are. And as I think everybody's saying, and Elizabeth perhaps most clearly, is we really have to be informed and inform ourselves in order to try to reach our own conclusions about so many of these issues. So again, on behalf of the ABA and the Law Library of Congress, I want to thank Steve, Elizabeth, Sophia, Wilfred, and Orrin for taking time out of their very busy schedules to share their time and their thoughts with us. They gave us a lot to think about, and we are just very grateful for your participation today. During this past year, it has been my pleasure to work with a wonderful and dedicated group of ABA volunteers and ABA staff. So before we conclude, I want to thank the members of the ABA Division for Public Education and the Law Day Working Group, who devoted a great deal of time, energy, and creativity as we planned this year's festivities. Also a huge thank to Frank Valadez and to Tiffany Middleton, who staff public education and really without whose tireless work we would not be here today. Again, another big shout out to Aslihan and the Law Library of Congress for being such terrific partners with us. One last time, please remember to visit www.lawday.org. We do hope you found today's program to be interesting, informative, provocative, and inspiring. More than anything else, we appreciate your participation in today's program, and we hope that you and your organization have found a way to participate in Law Day that is meaningful to you and to your organization and to the people it serves. Thank you again for joining us today, and this concludes our program.